Коллеги, добрый день.
Dear colleagues, we have a little problem here, technical problem, but Professor Valeryevich cannot join us. Well, we have to wait till he manages to tune his microphone.
Так, я вас слышу, вижу.
Все хорошо.
Тогда начинаем.
So we'll start. Dear, I have a script here. We have 15:03. We're starting. This defense of the dissertation of Vladislav Valeryevich Denisenko, seeking a degree of Doctor of Sciences, theory and history of law and state history of legal and political teaching. My name is Kozlikhin Igor Yuryevich. I'm the chairman of the dissertation committee, and appointed on the 18th of January 2021. And also other members of the dissertation committee include Ginevra Igor Nolukovskaya, Doctor of Legal Sciences, Professor, the Department of Theory and History of State and Law, St. Petersburg University, Nikolai Viktorovich Razuvayev, Doctor of Legal Sciences, Professor of the Department of State and Labor Law, St. Petersburg, of the Northwestern Institute of Management, with the President of the Russian Federation. Can you see and hear us? I liked your place. I was there. Professor Velik, does your microphone work? Yes, it's working. Okay. I can hear it. Professor Melik, does your microphone work? Well, it looks like it doesn't. Professor, can you switch on your microphone? Hello. Could you say something?
Yes, I can say something. Do you hear me? Do you hear me?
Так работает.
Do you hear me?
Yes, that's right. We are ready.
We're ready. Yes. I was afraid that something was not working. We can hear you. Professor Mitkevich, can you hear us?
Yes, I can hear you.
Yes. So we're continuing our work. We have a quorum. 7 members of the dissertation committee are present there in the committee. So we have the usual procedure. Well, don't overdo your time, please. First of all, we'll have a presentation from Denisenko. Just a few words about his paperwork. There are enough publications. All the paperwork is there. Do you have any questions for our candidate? No questions, perfect. Can we start? Dear members of the distinction committee, let me introduce my thesis, Legitimacy of Law, Theoretical and Legal Research. Legitimacy is one of the most important characteristics of both political power and law. Legitimacy in political science and sociological literature is traditionally interpreted as public recognition of certain institutions which is formed due to the audience's perception of social and discursive practices as legitimate, correct, and approved by these practices. Legitimacy is thus associated with the possibilities of the formation of certain mental states, images, assessment, behavioral attitudes in subjects. Such states are valuable from a pragmatic point of view because, well, this is quite possible that that if this order were uniform and unified everywhere, did not have any competitors generated by more successful practices, the problem of justifying it would not arise in principle. However, the real situation is different. The society is permeated with many conflicts, collisions, disputes over recognition. These disputes occur at different levels of social organizations, from interpersonal to interstate. The need to resolve these conflicts by resorting to legal means raises the problem of the effectiveness and efficiency of the latter. But what has been said about political problems is also true for the sphere of law. Firstly, political legitimacy does not exist in isolation from the legal one, because the compulsory application of legal decisions is monopolized by public authorities. And secondly, the need for legitimate law is essential even when there is no need to resolve the dispute, since conscious lawful behavior is a condition for individuals to assimilate certain collective values and a prerequisite for the interaction of various strata and groups of society on the basis of solidarity and mutually beneficial exchange. In recent decades, Russian legal literature has repeatedly attempted to specify the concept of legitimacy in relation to the legal sphere of society. The theory of law and state very actively uses such terms as legitimacy, legitimation, public recognition, the study of various legal problems. Therefore, well, there's no such unified point of view. For me, legitimacy is an essential property of power. From our point of view, legitimacy is nothing more than an essential property of law, and in this capacity it should be studied. An intrinsic property differs from a random property in at least two dimensions. Knowledge about it allows you either to explain some facts that have not previously found a satisfactory explanation, and to turn existing explanation into simpler and or more general ones, which is not true in relation to a random attribute of anything. The object of this distinction research is the totality of social relations that develop in the process of recognition by the subjects of law and of legal norms as acceptable models of behavior. The subject of this distinction research is legitimacy as an essential property of law. The purpose of this distinction research is to develop a scientific concept of the legitimacy of law corresponding to the modern development. We need to have a break because our Belarusian member of the committee is not online with us, fortunately.
Что, технический перерыв? Ну, не сегодня. Ну, ему уже сказали, наверное. Это Бьярн.
Тогда продолжаем.
Продолжайте, Юрий.
We're continuing. So, I'm continuing. The goal, this goal is predetermined by the need to solve the following tasks. The first one is to identify the social and conceptual foundations of the problematization of legitimacy in the general theory of law. Then to show the importance of a deep understanding of legitimacy for the theory of law and state. Then to determine the semantic concept of the concept of legitimacy of law. Third, to substantiate that the legitimacy of law directly determines the effectiveness of legally significant actions and decisions. To differentiate legitimacy and legality as properties of law, to show the context in which these characteristics are undefined and different, to explicate the connection of ideas about the legitimacy of law and the concept of legal regulation, to identify the various criteria for the effectiveness of legal regulations, to show the degree of their compatibility with the ideas of mutual recognition of the subjects of legal relations, to show that the crisis of legal regulation exacerbating in the post-industrial cannot be only overcome but also properly comprehended without taking into account legal communication, to analyze the phenomenon of legitimation of law, to establish a causal relation between the legitimation of law, delegitimation of law, and the loss of mutual recognition by the subjects of legal communication, to investigate the problem of legalization of society or excess of legal norms and its impact on the legitimacy of legal interactions, legal interactions, legal institutions, methodological and ideological foundations of the dissertation research. The methodological basis consists of general scientific techniques, which include definition and classification of concepts, inductive generalization of particular cases to the level of a reliable trend or regularity. And this also includes the principle of historicism, by virtue of which each investigated phenomenon of social existence necessarily contains traces of the entire preceding course of its development, and the principle of consistency. The philosophical doctrine of communication presented in the works of representatives of the Frankfurt School of Social Philosophy, including Habermas, is used according to this doctrine. Both instrumental and strategic actions essentially depend on the discussion of issues and problems that arise in the process of interaction between subjects. Since I don't have much time to dwell on this, for time constraints, I will turn to the scientific novelty of the dissertation research, and you'll see slides on the first. The comprehensive study of the problem of legitimacy as an essential property of law undertaken here is based on modern ideas about the structure of social reality, the interrelationships of its material and ideal components. This ensures the introduction into the domestic theory of law and the state of such concepts and interpretations that are not taken for granted for the Russian scientific community. Secondly, throughout the course of this research, the author tries to discover a fix in terms and sharpen those semantic oppositions that are required for the fullest possible comprehension of the phenomenon of legitimacy. These oppositions include the pairs legitimacy, legality, formal law, substantive law, system integration, social integration, etc. Despite the fact that all these concepts separately somehow figured, all of these concepts figured in social humanitarian works published in Russia, their semantic application to the field of legal phenomena was carried out for the first time in this dissertation research. Third, the work implements the idea of integrating philosophical and legal analysis with specific legal confirmation of the conclusions formulated at the highest level of abstraction. Therefore, the problems of legitimation and delegitimation of law are considered in isolation from practice, but in organic, not in isolation from practice, but in organic unity with the most important private public law issues. Theoretical provisions are put forward for defense. First, scientific interest in legitimacy as an essential property of law is caused by several objective reasons, among which it is necessary to highlight the conceptual and factual. The conceptual reason means the replacement of the positive or statist, if we talk about domestic realities, understanding of the right of the law, for a communicative one, which is characterized by social attention to intersubjective interaction as a way of existence of law. Since the communicative approach considers the mutual recognition of each other by the participants in legal communication as responsible and reasonable subjects sharing the same values as the key process of law genesis, the thesis about the volitional act of the state as the basis of the validity of a legal form is outdated and must be excluded from the theory of law. The actual reason for the growing attention to the problem of machines and understood as the phenomenon we have called the paradox of normative legal regulation. Second, the identification and study of legitimacy as an essential property of law denies the possibility of a formal legal ontology, that is, the presentation of law in the form of a logically closed system of norms. This presupposes taking into account the intersubjectivity underlying law genesis, the intentionality of the consciousness of the participants in legal communication. Focus on the meaningful other, and the organic combination of what is and what is due in law. The third, legitimacy. The legitimacy of law must be understood in three aspects. First, we're talking about the property attribute of the law. This is in the sense of Weber's sociology, and there is no absolutely everyone recognized legal order, absolutely recognized legal law by everyone. Secondly, we're talking about situation of voluntary and conscious self-identification of a certain circle of persons, agents who maintain the legal order. Thirdly, the legitimacy of law being the cumulative result of numerous interactions is a characteristic of the level of legal culture that a particular society has reached in its development. The legitimacy of legal prescriptions must be distinguished from their legality, which means nothing more than compliance with all the procedures established by law when issuing a legal norm, rules regarding the form of a regulatory legal act, the competence of the body issuing this fact, the procedure and the terms of entry into force of this act. For the society of modern society, there's a crisis of legal regulation. The problem is that legal texts cannot be understood by citizens. First one is technical, and the second one is more important, is the absence of the procedures of legitimization of law. First obstacle is removed by legal procedures. The second one can be tackled only by deliberative democracy, public discussion of legal acts, mediation, etc. Legitimation is the process of is the institutionalization of legal interactions. Legitimization legitimization is the process of gaining legitimacy by law, is the institutionalization of social interaction. But institutionalization presupposes the emergence of structures and rules that mediate this or that interaction. It is necessary to distinguish three stages of legitimation of law successfully replacing each other over time. Initially, the acceptability of spontaneously reasoned behavior's mode of action is found at the level of interpersonal relations and is maintained thanks to such a purely psychological factor as trust. Further, when the named model, due to its continuous reproduction, goes beyond the limits of personal ties into the sphere of the public, it needs to be fixed in legal text. the problems, the process of legitimation is completed by the full-fledged inclusion of a legal prescription and the communication between subjects. The problem of the delegitimation is when the mutual recognition of the legal text is lost. Thus, the process of therefore, if the problem of a low demand for law is not properly reflected, all attempts to restore efficiency to legal regulation are reduced to the production of redundant regulatory legal acts. Therefore, there's nihilism towards law. Legitimation of law always takes place in the field of opposition of two trends of integration. One of them social and personal integration. Involves the consolidation of the network of social communications, political and legal acculturation of individuals. For the purposes of system integration, neither developed reflexivity nor autonomy nor the creativity of social. You have only 1 minute. Nor the creativity of the subject actor, including in the legal field, are favorable circumstances. In other words, these tendencies confront each other. The legitimacy of a legal rule always precedes its effectiveness. If communicative subject-subject interaction is a universal necessary prerequisite for legitimized law, then discourse is a specific means of achieving legitimacy. The research results can also the theoretical and practical significance of the study lies in the fact that it represents the first complete and original concept of legitimacy as an essential property of law in the domestic legal practice. And the last point, the legitimacy when the interaction the achieving legitimacy is a set of thematically and temporally interconnected communicative events. Thank you very much. This is the essence of my research. Very important paper. We are there's an email you can send your questions to, and an online broadcast is being carried out of this defense. Any questions? Valeryevich, I have a question. From the presentation, I cannot understand. So I want to ask this question. The criteria of the loss of legitimacy. Legitimation is okay, but when you talk about delegitimation, how can you make sure? Can you be sure that this actually has happened? What are the criteria? Polякov Andrei Vasilyevich, professor of the the Department of State and Law of the Faculty of Jurisprudence of St. Petersburg University. Thank you very much. Can I answer all the questions together, or should I answer questions during the discussion? Well, maybe I could answer all the questions after all the reviews. We have one external review then from Professor Malinovsky of Moscow Foreign Relations University, MGIMO. He's professor in law. I will not read the whole review. It's a positive review about the critical remarks. The author of the dissertation talks about the legitimacy and legality of law. I can't hear you. Well, no. Legitimization is different from legality. Has to do with essential property. Needs a detailed analysis of the Institute of Law in different types of law enforcement. You use the theory of Jürgen Habermas, but he says that the facts of social life, he doesn't look through this theory, and rather uses a linguistic theory. So what's the difference between hermeneutic methodology and legal linguistic methodology? Well, the author also needs to talk about rational, irrational strategies of legitimization of law. Maybe we'll start with Canada. Professor,
I'm here, yes.
Are you ready?
To question?
To read your review.
Yes. But I will not read it exactly because it's a very lot of details of pages and reference to a lot of things. So I will more or less speak about my assertion. And I just begin with the examine the objective for the thesis. What do the Thesar, the candidate, want to do with his thesis? Because that's the most important. And I think it's very well defined when he said it's a question of defending legitimacy as an essential property of law. That's a big issue, very big issue. And I could just go on to criticize him about that and pose some question about what is the issue of essential property. But take that otherwise. What I just was observing is that when he was speaking about essential property, he's maybe too loose, maybe just not so precise that he should be, because when you read further, you just see that if the law should have an essential property, he just added to a concept of law. So you just have this structure in the thesis, a structure when you're saying that the law have essential property, and the other side you see that this is relied to a concept of what law is. And then the problem and also the beauty of the thing is this giving an ontology. It's a question of what the law is in itself. And that's magnificent for a thesis. But it's a great problem in legal philosophy. Because if you do identify law with ontology, you do not have anything other than ontology. You just have the ontology. And in the end, you just have the concept. So in my report, I've just mentioned this, and I was going to the methodology, because I was amazed how he has a lot of methodology. In the thesis, he was just enumerated one methodology, another methodology, and another. In some aspect, he have them all. But when we come back to the essential aspect of the structure of the thesis in itself, you see that it's really a philosophical thesis, because in some cases you do have only a philosophical one. But that's also very strange, because philosophy, legal philosophy, is not really a methodology. But I just see that when he's speaking about it, he's saying that he's applying basic categories in connection with abstract objects. What is the essential word here? He's saying that he's applying. Then he must always have the concept. And he must always have the meaning of the concept with him. And he must understand the conceptual as ontological of the law. But that's more or less what's called a philosophical conception of the law itself. So, yes, it's going. It's a theoretical legal research. But it's also a legal philosophy which is reaffirming itself as legal philosophy. I was criticizing that as saying that that's too dependent on legal philosophy. It's too dependent on theory. A theory that should always have been given. Later on in my report, I was examining the novelties of the thesis. And it do have reclaim 4 of them. But in some aspect, he do not have any or more than one. It's always the question of the problem of legitimacy as an essential property of law. And that is a very, very big issue. He's doing that very well. But you do have a long tradition, and ontology of law is not really a systematic theory of law. It's not really a communication theory of law either. So, when that was coming up in chapter 3, I must admit I was a little disappointed. I did not get the sense of this chapter 3. I was just having the sentiments that we was going to a psycho-sociological theory of law. We should be inside the theory in itself. But that's, sorry my friends, but that's typical Russian. Because a lot of theory in Russia is just going back to this psychological foundation about the law. It's coming from Petrevsky, and it's going out of Reisner. You find it in the different epoch of Russian legal philosophy. So, chapter 4. I did like it because it was entitled Legitimacy of Modern Law and Legal Regulation. And it's good. But in some sense, I just also feel some kind of disappointment. Because if you really want to look outside a philosophical, ontological theory of law, you do need some concept which is not inside the system. And that's even more if you really want a communication theory of law. And what was amazing for me was that what was interesting in this last chapter, it's what he's saying about trust and social capital. But what do I observe? I observe that he was setting this suddenly as a conclusion. It's like he was using the theory to come to conclusion that trust and social capital is very essential for understanding of the essential conception of law. But you should imagine that this should be the beginning. It should just begin and saying, this is the case, and then develop these two concepts. But I do observe that's not the case. The trust is just mentioned, said as a conclusion. And in this case, it do not have any real development. Social capital also concludes. But when it's concluded, neither social capital is developed inside the communicative theory of law. It's coming at the end when it should be at the beginning. So when I was reading the thesis, I was just amazed. Everything is there. But should it not be placed on another level? And for trust and capital, be placed in the beginning, so it could have a real theoretical development. But that's little things. That's about the structure of the thesis, but also how do you use your analysis to get your point about communicative theory of law, and also about essential character of this theory. But that's not so very important, because my conclusion is this is good. Very, very good. Because what the candidate is just showing is showing a good scholarship. From page 1 to page, the last page, what you observe is good scholarship. He have read the work in legal philosophy, in legal theory, legal sociology, and so on, and I have understood it. So when you making the point of this thesis, I'm just amazing. This is good scholarship. And the other thing is object for discussion. And that's what a thesis should be, in fact. A thesis is a question of good scholarship to show that you can do it. And I just want to say one thing. Congratulations. Good scholarship. And for the discussion, yes, I have the discussion. I have things to say. I have some question for you, but maybe that should be later on. Thanks.
Thanks a lot, Professor.
Thank you very much, Professor. Well, there's Minsk. Yeah, you are closer than Quebec. Thank you very much, dear Chairman, dear members of the Distinction Committee. I would like to voice my opinion as well about the distinction of Denisenko. I would like to say that I liked the legitimacy is as a key property of the positive law, and legitimacy has a practical and theoretical interest. And we think about this when there's a process of state building, nation building, and turbulence, maybe ups and downs of the law in the eyes of the population. That's very important, and we can observe that in our states, Belarus, and we have a lot of conflicts. And there are legal and conflicts, collisions and conflicts. Well, it's very important to address these conflicts with legal means. So I support the point of view of the candidate that the problem of legitimacy is not only within the state, but also of the global politics. In my review, I would like to say that this plan of work that is presented in the work allows to reveal the essence of the subject matter from different angles, and the author provides his own theory of legitimacy, and that's great. As the author starts his research with a philosophical and worldview points of view. Well, there's an integration of legal approaches and sociological approaches and communicative approaches. There's a borderline between psychological and other positive theories, and the arguments are quite valid. I like the analysis of the author of the literature in terms of the definition of legitimacy. well, the statement of Gelson concerning the legal positivism that identifies flaws. For example, any random meaning as part of law, and so the conceptual reflection on the previously unidentified links between theories is very important in a research thesis, and the candidate said a lot of things about the definitions, the different concepts concerning legitimacy. He referred to Weber, for example, and Habermas. Yes, it's a plus of the research. According to author, legitimacy is a property of law, and legitimation is a process these properties in which these properties are formed. The concepts are developed in the work. I positively evaluate the approaches to the concept of legality, and this right now it's very important. That is very relevant. That the ratio between effectiveness and legality, or rather feasibility and legality, is being discussed, and law always gives a corridor of legal actions, and they should be assessed in terms of desirability and feasibility. And social, he talks about concepts of political freedom and justice and other issues, concepts that are well understood by citizens. And legitimacy is the recognition of legal norms, is the prerequisite of enforcement of these legal norms, and this is very important. The key thought is in the literature, but not dominating. Very often we see when we try to solve social issues, we try to strengthen sanctions, and this is not the way forward. We should on the other hand, involve citizens in the solution of these problems. The positive thing is that the legitimacy is looked at from a historical point of view, and he shows variability of this concept. I also enjoyed the parts where the author talks about welfare state. Well, social state or welfare state is the organization of society that provides social services to people. It's we talk about it a lot, and whether we need to use legalism so much is an open question. The author also provides solutions to different conflict resolution, including mediation in public and private law, and I think that the conclusions are interesting and contribute to the development of Russian law and even national law, even supranational law, and international law and supra-international law. And well, in terms of my questions, it would have been good if the author to differentiate whether legality is the prevalence of the law in terms of both, not only legislation, acts of parliament, but acts of the court. Well, we talked about the Constitution, the constitutionalization of law is in the focus of Russian scientists and international science. In Belarus, for example, we also deal with it, and we talk about the constitution that conforms with international standards. Talking about democratization, you could have talked more about the subjects. This would expand would talk about the expansion of the rights of the population in governance. This is, on the whole, this is rounded research, has a theoretical and practical importance, in which theoretical provisions are formulated, and therefore the dissertation meets the key requirements of St. Petersburg University of the procedure on awarding awarding candidate of sciences and doctor of sciences degrees, and therefore candidate Denisenko deserves the right to be deserves to be conferred on the academic degree of Doctor of Sciences and Law. Thank you. Now I would like to turn to the members of the committee that are present in the room. We'll start with ladies. Can you hear me well? I'm used to being online, so we start with relevance. The topic is relevant not only for legal science but sociology and political science. But whether so, how does author actualize this topic of the dissertation? And I thought, how did that happened in the dissertation, and I thought of three things. Valeryevich believes of the normative activity of the government bodies. He believes that stative positivism it cannot be applied at the current level and at the present time, and he attacks this attitivism or stativism throughout the dissertation, and the author protests against the regression, the degradation of positive attativism to Soviet legalism. In terms of legitimacy of law, his approach is anti-positivism, but he doesn't provide. Provides his own theory based on the classical concepts and theories. In the dissertation, the author favors communicative approaches to law, or to the legitimacy of law. Well, this is good. Of course, is interesting, but Vladislav favors replacing one approach with another. Well, you could have issued a decree. Well, you cannot just replace something with something. You have to validate it. Well, all those things that I said talk about the relevance of the work and the novelty of the work. But can a dissertation be limited to the criticism of stative positivism? Maybe we should, the author should have developed different models of legitimation, and this is a task to be fulfilled. And I told Vladislav, you have to address Mikhail Antonov's questions. You have to pay attention to the arguments of those who actually don't believe the theoretical significance of the concept of legitimation. Well, Andrei Vasilyevich Polikov replied to Antonov, but not the author. Well, in terms of the validity, of course, there are a lot of conferences and publications, everything, expertise, everything is great. As far as the academic novelty, first one, the concept or the positing of the goal, the novelty of the dissertation is determined by making a legitimacy of law the problem as demanding a new treatment of this concept from the philosophical theory of law, but also including social humanitarian sciences, advances of social humanity. Well, you connect the questions of legitimacy of law with the problems of modernization of society, and you refer to the works of Weber, Bourdieu, Luhmann, and Habermas. But also, I looked with interest at the delineation of the traditional and rational models of legitimacy. And I think that the author creatively approaches this issue, and it provides a potential for development, especially the ideas of civil society as the subject of legal innovations in its dialogue with systemic state structures. And so this is a positive side of this research. Also, Professor Melkovic said that the criticism of the author of the instrumental understanding of a legal regulation, the actualization of in the distinction of the problems that have to do with legalization of society that can lead to the crisis of legitimation of law. I have no objections to the structure in terms of concept. First, you are a supporter of the communicative approach to law and a theory of communicative action by Jürgen Habermas. On the other hand, you stand for the communicative approach to law of Polyakov, and you emphasize on page 28 that in your understanding, law has the same meaning as it does in Polyakov's works. So you think about the law the same way as Polyakov, but later you see the similarity of Polyakov's idea with the ideas of Luhmann, and you look at Luhmann therefore as a positivist, as absolute positivist. Habermas is you object to positivism, and Habermas objects to positivism, and you say that the ideas of Luhmann differ from the theory of communication of Habermas, according to you. So there's a confusion here. Second, as a supporter of communicative approach to law, you also are in favor of legal libertarianism, and you refer to the similarity of Narcissus and Habermas. Yes, well, this was identified by Lopaeva. Yes, she did say that, but you don't only repeat what she says, but you add something. you see this similarity between libertarianism and communicativism as modern integrative directions of legal thought. However, you present the theory of Habermas as non-positivist integral theory. Integrative and integrative. Maybe this is there's a typo there, but then you say that Polykov's integral approach, you refer to this as a post-classical, that has nothing to do with the integrative approach. So, which of these theories lies in the foundation of your concept of the legitimacy of law, integral or integrative? The third one, when you criticize the traditional society, traditionalism, I looked at I reread your book. Well, you bring down traditions. Well, there's explosion there in your book. You're much softer in the station. You criticize different communitarist versions of legitimacy, and you believe that in modern society legitimacy cannot be implemented through religious and traditional norms, and the detachment from the traditional religious idea, you see these ideas in the works of Polykov, Frank, and Ilina. You see this detachment as inevitable. Well, should we actually drop the religious cultural roots? Maybe we are overconfident in terms of the power of reason. Even Habermas was not so categorical, and Habermas, he actually coined the term post-secularism. He looked at it as a discourse that sets up a dialogue between religious and secular consciousness. So, would you, are you ready to correct your position, or on such dialogue in your concept is not even needed? The fourth. One of the promises of the dissertation is the theoretical provision about the legitimacy as an essential property. Yes, according to the communicative theory of Polykov, law doesn't exist without its recognition that it exists. But according to libertarian theory, it's the opposite. The existence of law based on the principle of formal equality is a prerequisite and the criteria of the legitimacy of law. Fifth, according to the author, legal order is legitimate only in the case that it doesn't contradict positive law, in the case when the positive law doesn't contradict the moral principles of society. But libertarianism or libertarianism would not support that. But the supporters of just naturalism would support you, and I would support you too. And unfortunately, you exclude from a discussion not only positivism but also natural legal theories, natural law theories, unfortunately, even without taking account of their post-classical modification. And the sixth, not the sixth yet, but can the author explain the exclusion of just naturalism from the current legal discourse? If the author is that supports integral or integrative theory of law that includes the idea of natural law, as we all know. Number 6, how can you make compatible the understanding of the legitimacy of positive law as its recognition or acceptance of the subjects, i.e. External behavior, and the implicit and explicit legitimacy, because implicit legitimacy is the internal property of law. According to Polikov, the internal property of law is substantive or essential. Maybe you should correct yourself. Well, there's some liquidity in the narration. Maybe the topic is very, very fundamental, and it generates a lot of discussion. You have 400 sources. Well, you refer to different sources, different theories, concepts. So it's hard to harmonize your literature review and crystallize your own theory. But you do that. But you managed to do that, and so my conclusion is that the author deserves the right to be awarded the degree of Doctor of Sciences. 10 minutes is the 10 minutes is the limit for reviews. I have a document in front of me that says that. And then I will have to stop you. Marina Gennadievna wasn't happy with to be second. Nikolai Viktorovich, 10 minutes. I would like to side with my colleagues' statements. First of all, with Geneva Igorovna, that's the topic of the dissertation is both relevant and fundamental. The relevance is determined by the need to reassess qualitative assessment of the category of legitimacy in the context of post-classical understanding of law, post-classical paradigm of law, with its conceptual nomenclature and vis-a-vis the classical concepts. And classical jurists gave definitions to legitimacy from first formal legal definitions, then sociological, and the author finds his own definition that is aligned with post-classical understanding of law, is a cultural anthropological understanding, because this refers not only to external factors but to fundamental characteristics of human personality, psychology, mentality, and volition. And the discourse and the research is very interesting about it. The phenomenon of legitimacy is connected with a very important characteristic of trust that determines the behavior of members of society. This is the most important problem that has been discussed for a long time, and now. And so trust now whether and therefore whether when we sanction, is this the only way to determine behavior of people? So the legitimacy of law is then connected to the behavior of people. The problem of legitimacy is determined by the goals of legal process as the interaction of individuals, and therefore the behavior of individuals is legitimized by the fundamental characteristics of the individual. Vladislav Valeryevich builds his own concept, juxtaposing it with classical just naturalism, and based on the just naturalism, it juxtaposes with his own concept, and also juxtaposes just naturalism with the modern concepts. Well, the idea that the non-classical understanding that he refers to the Enlightenment period, the ideas of religion and irrational ideas, and the dropping of this in the Enlightenment period, shift to reason. Well, there was a rationality even in the Middle Ages, for example. There was rationality in the Renaissance period. This is an evolutionary process, and the ways of legitimation of law has undergone an evolution, and this is a product of evolution. But the provisions of the statements of the author are very interesting and have great potential, and this consistency of development of the theory that is presented by the author. There are two maxims that is inherent in post-classical understanding. First are the main what are the universal properties that are actualized in any legal order, and he believes in this. I think that the author validates this social, psychological, and cultural constants that determine the legitimation. It's either suggestive or emotional or rational, and this shift from the suggestiveness to rationality is a historical process. Olga Freidenberg talked about it in the antiquity. From image, they went to notion, and there are some. I agree with the candidate in most important aspects, but there are some issues that some statements I cannot agree with. I don't think that you shouldn't delineate the modern society and classical society, pre-modern society, on the basis of rationalism. Prehistoric man, of course, is different from us, but once we get into the organized society, then rationality plays a very important role. Well, the author critically looks at the delineation of the public and private, society, our law, and this has to do with this is a left-leaning liberal ideology that advocates a welfare state. Vladislav Valeryevich created a caricature picture of private-public regulation.
Война всех против всех, но это ж не так.
And this is the war of all against all. Civil society and private legal order is a special type of regulation based on free covenants, and the main instruments are the agreements between members of society. So there shouldn't be a divide between the state and civil society, but rather of the intertwining of such things. These critical remarks are of a discussion nature, and I believe that this was huge work, and this dissertation deserves deserve a degree.
Все равно больше 10 бы говорил.
Тут я старался.
Старался.
I tried to shorten. Do we have a break? Do we need a break? Somebody wants a break here. Andrei Vasilyevich wants a break. Do we need a break? Well, you take a rest at home, Andrei. Members of the station committee, Ilya Lvovich now will present. Dear colleagues, the dissertation is characterized by the relevance and the legitimacy of law started to talk. Legal sciences started to talk about it in the end of the 20th century, and but it was not. It was mostly approached through sociological and other approaches, but Vladislav Valeryevich took up this banner and tackled this issue. He conceptualizes the legitimacy of law, but he aligns the legitimacy of law with the structure of social reality. This is a postmodern methodological integration of formal levels with empirical levels. The author he favors the theories of Bourdieu and Habermas. He criticized Marxism, the ontology of law, according to the author, is the legitimacy as a specific relationship between the subjects, as a view of non-positivist view, this, well, he tries to smoothen over the contradictions of different theories. He talks about his adherence to post-classical concepts. Law has become needs a legitimacy, and in order to work, it should be based on legitimacy, and therefore law, the legitimacy of law depends on the recognition of in society of legal norms. I think that we can talk about, you can cite different other positive aspects, but I think that I see 5 critical points. The first one, the author. The author doesn't rely on one theoretical legal paradigm because it doesn't exist, and he thinks that it's not even useful because the Soviet experience talks about the uselessness and even detrimental nature of such a unified doctrine. The second, I would like to ask what conceptual reasons to remove the stative concepts with communicative approaches. First of all, but the author agrees with the process of legitimation includes formal legitimation. And the third, in the paragraph 2, the difference between legitimacy and the legality of law needs more concrete conceptualization, and also the definition of legitimacy of the positive law as the recognition of positive law needs more concretization, and also there's no answer to the fundamental question about the interaction of different levels of legitimacy, such as legitimacy of interpersonal interactions, and how it relates to the institutionalized non-personal legitimacy. Nevertheless, my conclusion is that the defendant deserves the degree of Doctor of Science. Marina Gennadievna, dear colleagues, I asked to be asked closer to the end. My review is positive. I think is very important for the science. Legitimacy of law is one of the key characteristics of law and political power. We had a conference that had to do with the legitimacy of law. There was a clash of opinions, because the legitimacy of law can be referred only to political power, but also can be assessed as the property of law. I support the candidate that the legitimacy of law is a key characteristic of both political power and positive law. And legitimacy is connected with the capabilities, the opportunities to form specific mental states, images, assessment, behavioral motivation in subjects. And the dissertation fills the gap in the discussion of this topic, as he provides the concept of legitimacy that is based on the understanding of the ontological status of legitimacy as necessarily is inherent in law. And the review is published. I will not read all of it. I will try to keep to the time, and therefore I will dwell on some things that are controversial. The first one, and the author talks about the legitimacy of law and the legality of law. And the difference he sees is that this difference is not is just the compliance with the legal procedures when this legal norm is issued. And I think that the ratio between the contrast between legitimacy and legality of law should be revealed in more detail, because there's a confusing statement to my mind that says the formal rational legitimation cannot be considered a universal characteristic of a legal order. The second remark is that the author says that in the informational globalized society there's a constant process of forming a single socio-normative space. And I have a question: is there a consensus in the legal regime of an emergency state? Well, this should be clarified. The third one, Denisenko says that besides parliamentary deliberations, there must be an inclusion of or participation of citizens in creating and law enforcement, creating of law and law enforcement. I have a question. And whether it's in the interest of citizens, the right in the law, whether the interests of citizens are implemented in the law in a digital society, which is characterized by hyper reality. And maybe the author should have clarified it. The second one, the fourth question is, what is the role of irrationality in forming legal ideology today in the conditions when a legal space is determined by some legal scientists as including quasi phenomena, simulacrals. This problem is very relevant. Nevertheless, the dissertation of Vladislav Valeryevich meets the key criteria of the procedure on awarding academic degrees in St. Petersburg University, and therefore Vladislav Valeryevich Denisenko deserves the right to be awarded an academic degree of Doctor of Legal Sciences in the degree field 120001, Theory of History of Law and State, Historical Teachings of Law and State. Thank you, Marina Gennadievna. I am the last one.
Соображения по
I listen to the colleagues, and I think I'm behind the academic thought. I am in the 20th century. Well, this is an eternal question. Why do people obey law? This first one is there's fear and there's convenience. Well, if you are afraid, you obey the law. For example, with barbecues, but there's also convenience. Barbecues are forbidden at the dacha. Well, nobody will obey it, and you can do anything with us. Andrei. Three weeks ago, I talked to Andrei Vasilyevich, and I said that between trees there are no legal relations. There are no people, there are no legal relations. But in Habermas, he is not a legal scientist. He looks at it differently. Very interesting way, talented way. The community of action. Well, people, let's be friends. We educate each other. We treat each other as equals. This is utopianism. It's very good to deal with congenial people, and Jesus Christ taught us this. But people are selfish and wicked and all sinful. And Kant knew it. The interaction is not bona fide. How to avoid conflict?
Нам зачем право?
If there are no conflicts, we don't need law. We are all friends. Well, this is a whole new theory. Well, let's just chuck out state from the theory of law. Well, we can say we have no criminals. Well, we just ban them, and but they don't leave us. I will not read the whole review, but the main thing, the essence of the notion doesn't depend on the notion. I'm a conservative person. Jering said law is a system of norms that exists in the state. Well, it's simple and clear. This is a problem of not legislators of state, but the fabric of society. If, according to Aristotle, if the fabric is good, that's everybody is friends to each other, friendly to each other, then, well, will never happen. People love each other, and therefore children are born. If nobody loves me, I'm not human. I have no essence. When I'm loved, I'm not human. Somebody fell out of love with me, I got divorced, I'm not a man again. So, this Mark Twain, there's a story by Mark, mysterious visit of a tax inspector. Tax inspector is being tricked by this individual. The tax inspector is trying to trick or arrest or capture, and so this kind of conflict can be only resolved through the criminal code. When Vladislav advocates deliberative democracy, discussion of laws, what will it give to us? Well, we discussed the Constitution recently. What has come out of it? When you hear a deputy saying something like this, when I read bills, my head blows up. Well, this is a member of parliament. What can we say about us? Well, there's a theory. Each theory has to align with reality. Well, we can talk and talk about something, paper, what will carry. Well, but on the whole, I still support the awarding of the degree. And then now we have answers to the questions. Thank you very much for your positive assessment of my work. Thank you. Special thank you to my international members of the committee, Jan Melkovic and Professor Valeryevich, and I will sort of amass the questions and answer them in a generalized form. First of all, I would like to answer with Professor Kozlykin's remarks. I will start with Kant, if I remember correctly. Kant had something like this: the problem of good governance can be solved only for people of devil. And this is a good expression. It characterizes the period and time, well, that it was enough to develop an institutional mechanism. When we talk about the problems of legitimacy today, my first answer is about methodology. Methodology of communicate action is not utopianism. It's not Thomas More or Campanella, but this is some legal ideology of a legal reform. These legal reforms are in action and have been completed in some countries. The criteria of whether a theory is utopianism or practice, there's paradigmality. Whether it entered the practice of law. In textbooks in modern political philosophy, Will Kipling, there's a fact, a deliberative transfer when the legislation of England was changed under the ideas of Habermas, and the legal procedures are working at the level of constitutional law. They exist. As far as the legal education, it is necessary, because if we use only laws, universal standards, as in the ideas of Enlightenment leaders. I'm not against Enlightenment. I'm not a relativist. I am adherent of postmodern. It has connection with positivism. We have to take account the level of citizen consciousness, anthropological understanding of the action of law. In Mexico and in America, they have the same constitution, but the corruption levels are different in those countries. The phrase that I started with, Kant's phrase, is good, but it's not as easy. There are positivists in our community that rejects the problem of legitimacy. Yes, there is a point of view like this, but the modern society demands a new understanding of these problems. There's another quote of Mark van Hook. Kelzer's theory as pure teaching means that if you put an individual through a sand-dusting machine, this individual will be clean, but it will be just a skeleton, and will not survive. And well, this, as far as legal education, yeah, so legal education has an impact. As far as the other comments, first of all, these are questions about the difference between legality and legitimacy. Professor Smirnova, Malinovsky put that. Andrei Vasilievich Polyakov, the author of Communicative Theory of Law, contributed a lot to the popularization of this theory in our country. The legality and legitimacy are different sections. Legitimacy is a description. If we talk about empirical dimension, 50% voted for this and that amendment. This is legality.
Законно или незаконно? Законно.
We talk about whether these elections are legal or not. Legality is the legality of all actions of law, not only of parliament. As far as the legitimacy, we have a different meaning here. In my context and in my methodology, is the necessary involvement of all parties who are interested in this result. If they are allowed to participate in creating the law, if people are excluded from lawmaking, then a law is not legitimate. Andrei Vasilievich?
Они, безусловно, указы президента.
And decrees of the president are legitimate, and the acts of the government, because legitimacy cannot be direct. This is indirect democracy. It's not direct democracy. Legitimacy, this is the idea of deliberation, of participation. If the population has no impact on the executive branch of government, then the action or the power itself, the whole set of branches of government, then the acts should not be considered legitimate. If we understand decrees of a subject as some volitional acts that as public or private autonomy, then they are not legitimate. As far as the issues of modern society, this is a very relevant topic. The problem of legitimacy is actualized in this digital society, information-based. The notion of hyper-reality has an impact. There's blurring for citizens of the notion of public opinion. According to me, we have the formula of procedures of deliberative participation of in law making. In the past, there were notions of welfare state or and other types of society where people were ruled by society. Weber said as the metal cage of law, and you mentioned that when a law regulates barbecues and the dacha, and now we have this new, the advent of digital society needs a new understanding of law and the delegitimization of law. So deliberation, participation of citizens are key here to
Розвиваю.
Professor Rozovayev's questions. Thank you very much for your questions. I would like to about rationality, redress rationality. I don't have this dichotomy because traditional and modern society. I would like to say rationality is accompanied by the formality of law. In my thesis, I don't put rationality in opposition to mystic consciousness. Law is material. Can all be sovereign? Well, it's like in Byzantium, or there are things that cannot be sovereign, as Locke said. There are terminologically I would emphasize here the theory of social capital. As far as the Professor Chistov asked, wrote a lot. He wrote a lot about different issues in this area. As far as the worldview, the basis of the worldview, the basis is communicative action theory. And I advocated this position. As far as the paradigmality, I meant only meant a monopoly on the of understanding of the understanding of and on the paradigm, the monopoly of the paradigm of the discourse as it happened in the Soviet Union, and so that we can discuss anything from all points of view, from all affiliations, political affiliations. As far as then the the replacement of positivism with communicativism, maybe maybe I should have said that this word should be replaced. Well, the word to replace, but those people who remember the theory of law, there are the history of law and the theory of law. There's a connection between the beginning of the concept of in law and the popularity of this concept. First popular statement is that state is not the only source of law, because this international law and positives try to reconcile themselves to it. There are many other subjects of norm making. The second objective reason is the process of hyper-regulation and juridification. This is the trend of the 21st century. Luhmann used this term. Habermas had to resort to law in the communicative sense. Law cannot be viewed as in a pure way, where in the modern era, when there's hyper-regulation of all aspects of society. So this impacts legal doctrine, of course, as far as the legitimacy and legitimation. These are this property and process. The formal legitimation through a procedure is a type. There's also essential, and essential legitimation is more favorable now. As far as the question has to do with James Scott's works, like forced, who talked about forced legitimation. The author is not objective enough, because legitimation, when it's forced, it's manipulation or suggestion, mental suggestion under the threat of violence. Because this legitimation, if we consider this a recognition of law, then it should be voluntary.
Далее, что касается ответа...
As far as the Professor Valeryievich's questions, Professor Valeryevich says about the problem of norm making and constitutionalization. This is the process of inclusion of constitutional norms into a society. I think these are different levels. This is general and private constitutionalization is at the level of international law. Legitimation is at the national and international levels. The procedures of consensus in the European law, well, everything is voluntary there. As far as norm making or law making. This is a very broad issue, but I believe that in expanding the object of legal regulation, legitimation must be connected with the understanding of by a subject of norm making through deliberation. In some modern countries, in constitutional remork, in Ireland, and they use that to resolve conflicts at the municipal level and regional level, and people deliberate and they understand each other's opinions. And, Professor Lukovskaya's statements, comments. My worldview for legitimacy. This is concept of communicative action. This has to do with reality. When we talk about this is textual analysis. The concept of communicative action has to do with praxeology, with practical sphere. This is the concept that is the methodology for the study of legitimacy, well, including empirical methods. Well, integral or integrative. In science, I draw upon Polyakov. We use integral. Integrative is a combination, but it's not about the terms, it's the understanding. When we combine in the ontology of law instrumental and communicative action, they're not this is not mechanical combination. As far as post-speculative dialogue, it must be there. I agree with it. Not all societies are developed enough for this. I don't object to Habermas. He talks about dialogue.
Способный диалог другого субъекта.
You have to see another as a subject. Unfortunately, in our society, there are legal constraints on the emotions of other people, and so there's no dialogue. Well, over a period, there's a line between formal equality and mutual recognition. The borderline is disappears. In Habermas, the involvement of other. Habermas criticizes naturalism. He says that Plato and Eidos, this is naturalism. Natural law is classical. This is Plato, naturalist, Eidos. I worked on the distinction. This is a very big topic. It's very hard to refer to everybody with contributions. The authors can go away from this terminology, but it don't succeed. Habermas says new natural law is a metaphor. It's not an eidos for him, but as type of socialization. Mutual recognition comes from socialization. The last comment from Jan Mielkovic and Professor Malinovsky, from what has not been said. I agree with Professor Jan Mielkovic. Some clarifications. Post-metaphysical nature of law in Habermas is the position of communicative rationality. This transfer to practice is not complete. Well, I should have talked more about mediation, but I didn't have this aim. I wanted to outline the strategies of legal policy. As far as the understanding of legitimacy and social capital, the understanding of legitimacy is not a normative understanding, as a descriptive understanding. We view legitimacy through the involvement of people, through a discourse of participation, because we understand, if we understand the expansion of law into the private sphere, if we don't have deliberation, as you as Professor Brian Merkel said, there will be legal hell, and this will lead to the delegitimation of law. And the last comment, answer to the comment of Professor Malinovsky, I talked about the ratio, the comparison between legitimation and legitimacy. A linguistic understanding is through a performative act, a word as action. This is a methodology. This is not a theoretical construct, but a basis for legal policy. And there are prospects. If we look at Raymond Leger about culture, anthropological shift in law, the idea of essential analysis of law, not just formal analysis of law, is very significant. Are you all happy with the answers? Any people who would like to speak up? Andrei Vasilyevich, 2 minutes, not more than 2 minutes. The members of the Session Committee, you probably noticed that I was very emotional. I know Vladislav. I have known him for a long time. He has graduated from the department where I work, and several years of my life I helped him to get to know this topic, and I recommended some ideas, and we, Vladislav and discussed these ideas. when the last version of the dissertation was brought to me, I actually recommended that the dissertation be brought for defense. I shared these ideas. I'm the adherent of the cumulative approach. But I thought that there were some problems that we heard about today. First, and I thought maybe this dissertation should have been postponed. This dissertation, and Vladislav said, "I have a brilliant dissertation, and I will defend it." And Vladislav was right. My criteria of the preparedness of dissertation were too high. Listening to you, and I just heard I heard especially, what amazed me. I disagree with everything, but I believe that this dissertation should be endorsed. I'm very happy that the candidate will be a doctor of legal sciences, because I stand for these ideas, and the dissertation, that such a dissertation will be defended successfully is great. It's like an icebreaker. Fourth minute is this is an icebreaker. I know many people who work in this context, and have dissertations ready for defense. And so you'll have work to do. So, Vladislav, I congratulate you on the. I of course anticipate the positive resolution of the. I agree with the. I don't agree with some conclusions, but I agree with the ideas. A question. 2 minutes. Even 1.5 minutes, please. Professor of MGIMO of the Comparative Theory of Law, the dissertation committee, I urge you to support our candidate, because this is a colossal scientific courage. Because when Denisenko sat down to write the dissertation, he had no methodology. How to tackle this legitimacy, because as a methodological concept, I liked the statement, the review of Genevieve Igorevna. I was told about you that you shoot like a sniper. Well, when you shot Denisenko, then your bullets go to Habermas, to others. Moscovich visited you. Archetypes of young Tsar, the Tsar, the father Tsar. All this are parts of Russian mentality as well. And this is all to be taken account of, but I totally endorse this this dissertation. Do we need a break to deliberate? Well, let me get back to my script. I would like to I put for voting the resolution to award the degree of Doctor of Legal Sciences to Denisenko Vladislav Valeryevich. This is an open roll call vote. I would like to ask each member of the station your opinion. Nikolai Viktorovich, Genevieve Igorevna, yes, in favor. Nikolai Viktorovich, yes, in favor. Marina Gennadina, yes, in favor. No. Ilya Lvovich, I'm in favor. Grigory Alexeyevich, for. Bian Melkovic,
For.
za. And now, so 7 people voted. 7 people voted for it. So the resolution to award the academic degree of Doctor of Sciences is successful. Thank you very much. Congratulations to the candidate, and the concluding word from dear Chairman, dear members of the Dissertation Committee, dear guests, Andrei Vasilyevich. I would like to thank you for the positive evaluation of my work. This is a great honor for me to stand in front of you in St. Petersburg University, in front of the specialists of international level, because here in this building, this university, there were traditions that have to do with the philosophy of law and legal teachings, and the problem of acts of law and supra-legal law. All these ideas made this university famous, and the School of Philosophy of Law. And this is a great honor for me to defend my dissertation here. Thank you very much. The session is over. Thank you very much.